Hello everyone, welcome back to Miss Hadley History. Let's get back to those constitutional amendments. Today we're talking about the 4th Amendment, and this is what it says: the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall be issued but upon probable cause supported by oath or affirmation, particularly describing the place to be searched and the persons or things to be seized. This amendment was yet another reaction to what the British were doing in the colonies during the Revolutionary War. Oftentimes there would be general warrants that were set up for soldiers to implement while they go through houses, they search, and they would seize anything that they deemed suspicious. And so this amendment was basically created for the new government to make it so that each person had their own castle, their own home, and that they did not have to worry that a policeman would come in and just randomly start taking their stuff. Now, this amendment does say that if they have a reasonable excuse to come in and search, they are allowed. That is the whole point of a search warrant. And basically, if they have a search warrant that's signed by a judge, then they are allowed to come and search for specific things pertaining in that search warrant. This particular amendment has been evoked several times throughout the years because the reasonable search and seizure has been tested throughout our history. One particular case that is significant is the Weeks v. United States. This is a case regarding what was thought to be an illegal search of someone's house, and it ended up going to the Supreme Court and established the exclusionary rule, meaning that if there is an illegal search done, meaning they don't have the proper paperwork, they cannot use any evidence they find in court, which helped promote the idea of actually going through the legal system. This amendment has also been brought up with the idea of stop and frisk, which in 1968 there was a court case about that, Terry v. Ohio. Unfortunately, it was deemed that if there was a right amount of suspicion, that it would be allowed to be done. Next time we'll talk about the 5th Amendment and what exactly it means to plead the 5th.